Before we go into the public hearing, yeah, I have a couple of, under portable signs, and you mentioned the A-frame signs, particularly in the downtown, and then also other businesses that have to be placed on the property of the business. What is, what are the limitations are there size limitations on those? And I guess my thing is, I see a variety of A-frame signs as you travel about the city, not necessarily downtown, but there are some downtown. And I have some concerns. Some of them are, and not to pick on anybody's penmanship, but it looks like, it's just kind of a scratch and a very archaic printing and that sort of thing. To me, if I were a business owner, I would probably want to have a sign that was pretty professionally done, to at least advertise my business in a professional manner. And I know that this is going to be, at best, something that's going to be hard to enforce and that sort of thing. I guess, what is the necessity of having an A-frame sign when you have signs in front of your building and that sort of thing?
Typically businesses that are set back from the street, this obviously doesn't apply to the downtown, but elsewhere in the community where they have parking in front and they're set back a distance from the street, want people to recognize that they exist in that shopping center, and so they will often put signs out closer to the street that have their name on them, sometimes even a directional arrow that points towards the building in which they're located. So it's a way to get identification at the street level without necessarily being on a monument sign or on some other structure that's maybe permanently there. It's an inexpensive way for a small business to do that. We do have a size limitation. This was something that was suggested by the DDBA for some of their members, and we applied it to citywide. They cannot exceed 10 square feet in area, and that's per side, because they're usually double framed. And then it can't be higher than 4'6" in height. And that's still subject to making sure they're not causing a sight distance problem. Now in the downtown that won't be the case, but other places there we would look at that to make sure there's not a sight distance problem. We do have a requirement that they be professionally manufactured, and I know that's a somewhat subjective thing. I know the city attorney was not thrilled with that provision, but what we are trying to avoid is somebody just literally taking their felt tip pen and having at it, and it does sort of send a message of quality, I guess. And so by requiring it to be professionally built, painted, created, that we hopefully will have a little bit of quality that we'll obtain.
Over on page 3 of the ordinance, on item T, temporary signs. What is it says for a limited period of time? Is that defined specifically 60, 90, 120 days? I mean, limited time could be from now until
it isn't defined.
2050.
Theoretically, they would be always considered temporary but not permanent, but in reality, they could be up for a number of years that they almost appear to be permanent. Temporary in itself is something that you would imply that would you take down, but there's not an obligation now that you remove those signs, simply that you maintain them.
Okay. Having said that, is there some kind of a requirement that those, quote, temporary signs, as they're hanging about for several years, tend to get faded, ripped, and torn? Does the owner of those signs, is there some provision that they have to replace that or maintain that in some reasonable manner?
There isn't per se in this code. There is our nuisance ordinance, a public nuisance ordinance that would apply. We talked about signs that are torn or tattered or have dislodged themselves partially or completely from where they've been attached. In those situations, staff would notify the business that they need to replace the sign, and that hopefully that we would be successful in getting that done or reattach it to the building properly. But right now there isn't specific language that describes what maintained means other than what we have in our nuisance ordinance, which talks about maintaining a property in a certain level.
And then my final question, on page 4, item L, no inflatable sign shall be allowed. I'm presuming these are like helium balloons that you see in some car dealerships in another town down the road.
Correct.
To the west of Dixon. And also the famous little blimps that are
Correct.
You see floating about. And
We've had some issues with that in the past. Typically, they want to put them on a roof, and we've been able to say no because we don't allow signs above the roof line. But there are some instances where they want to attach them to the ground. And so again, to avoid any confusion, we simply put this language in that said they're not allowed under any circumstance.
Does that also apply to the inflatable arm flailing guys?
I would say yes, council member, because it's designed to attract attention, and that's what a sign really its main purpose is. So yeah, if you saw one of those things that are sort of inflated by hot air, like the kids' jumpy things, I would argue that that's an example of an inflatable sign, and I would ask the person that, based on this section, that they be removed.
So anytime someone puts up, I'm sorry,
No, that's fine.
sorry.
Go ahead.
So anytime someone's going to put up, say, an A-frame sign, they do have to go through a process where they were reviewed and say, this is professional, this area is okay, the size is okay?
Yes, I mean, that would be our preference. There would be a minimal fee involved for the initial installation of that sign. It's $30. And then after that, they would not be subject to a fee on an annual basis or any other time.
Okay. And also, for enforcement of this, is it complaint driven, or if someone's driving around?
Probably
enforcing
both. Because we now have this ordinance in place, if we see someone that's violating it by placing it in an area that it's not allowed, we might take the initiative to advise that business that they're allowed to have the sign, but they need to relocate it to an allowed area. For example, there are areas elsewhere in the community where they're placed on the sidewalk, where there's private property in which they could legally display them. In those situations, we would say, could you please move them from our sidewalk onto your property? In the downtown, we'll go through an encroachment permit process where we have a liability issue that we need them to indemnify us on. That would not apply in the rest of the community.
But there is a set list of things you have to do to notify someone that they're in violation, and
Yeah, typically we try to make face-to-face contact in a situation like you're describing, and just advise that business owner, please take the sign and move it back a little, or if it's causing a sight distance problem, can you move it in some other location to just absolve that problem? We would only resort to writing letters if we've either failed to get compliance or it became a recurring event.